Welcome, law students and continuing education, lifelong learners, and all persons who are interested in learning more about law in a vocational and, of course, continuing education setting such as this. I am Dr. Tigress Sydney Acute McDaniel, Juris Doctor, your ethical law professor. So, welcome to our first day of class. This is so exciting. I had to take a pause there because I wanted to record this live, but of course, in that this is a new platform, the socials do not allow for me to actually record live until I meet a certain threshold, of course. But at this time, you can definitely follow me. And of course, please subscribe here, turn on all notifications. The handle is at the Ethical Law Professor. In fact, it's that same handle everywhere on all socials except for X. And I will not be very active on X, but some of you are already familiar with me, and you know that I am also a 2-decade veteran in entrepreneurship and business viability. And so when it comes to branding, I'm going to go and make sure that the branding is branding. Do you understand that the brand is branding? So, of course, I have assumed the handle on all socials for that uniformity. And on X, of course, they have the character limit, which it is known for. And it has the character limit for the handles as well. And so in the interest of synchronicity, I just went ahead and used the handle, the Ethical Law PR, because that's all the characters that would fit. And I preferred to actually have the in our handle because the is actually one of our newest trademarks. So it was coming with me. So if you're not already, definitely consider subscribing to our other platforms. Some of you also know me as Queen Get Her Done, the Queen Get Her Done. And of course, you can find me on all socials at Queen Get Her Done and or at the Queen Get Her Done as well. And of course, you can follow along for the journey of becoming more informed for your personal development, for the evolution of society as well, and betterment of society, the strive toward peace and true civilization. That is the primary mission and vision of this educational platform. So I hope that you will subscribe and you will share. And again, turn on all notifications. And that's enough with the intro. Class, let's begin. Today we are covering the fundamentals. We're starting with the fundamentals, statutory procedural law. And we're going to start with some that are controversial, if you will. And we really highlight the objective truth here. I would be likened to a pragmatic, if you will. And that just means that I follow a strict policy that right is right and wrong is wrong. And that we all inherently, intuitively are equipped with knowing right from wrong generally. And that's what I promote. And I don't promote favoritism. Right is right, wrong is wrong. And if we were to get to that objective baseline, I think that we would be so much better off, because what has taken hold of our societal interactions is quid pro quo. Corruption has become status quo. And when you're talking about quid pro quo, you're talking about transactional relationships. All of you all know all this stuff. And so it's like you scratch my back, I'll scratch yours. And all of that necessarily turns into and rears its ugly head as corruption. All right, so let's go ahead and let's discuss the objective truth as it relates to hearsay. So I'm going to share my screen. Let's see here. And I'm going to put on my glasses as well. Let's go. Alrighty. Now, most often, people hear that hearsay is not admissible in a court of law. And honey, if I had $1 for every time someone was so sure that hearsay could not be admitted, or even when I've actually heard a judge from the bench, in fact, regurgitate this knowing false statement that hearsay, this blanket statement that anything hearsay is not admissible in the court of law, I would be richer than Elon, okay? So here's the truth. There are uniform statutory procedural laws. One such uniform law is that for evidence. So the rules of evidence are the same, uniform, for both state law or state statutes, because statutes are laws, if you're not aware. And keep in mind that I am doing this from the scope that you may not have any information about law or that you are insufficiently informed in law. So this is not me speaking to you in a demeaning way. That is not ever my intention. All right. It's uniform. The state statutory rules of evidence are uniform, or of course they were informed first by the federal rules of evidence. And they're even codified by the same numbering, okay? So it's Rule 803, and we're going to go straight to it. We're going to go to the exceptions to the rule against hearsay. And in fact, this will be included, this class session will be included in my playlist for there's an exception to every rule, generally, all right? So here we are, we're discussing exceptions to the rule against hearsay, right? So let's first go to what is hearsay, all right? And you'll notice that I'm toggling between the federal rules, which you can find at the Legal Information Institute for the Cornell Law School. You see the website address here, and the North Carolina General Assembly, the website here, for the statutes, the North Carolina General Statutes, okay? So we'll go back. And these are very easy to navigate. You'll find that they're very easy, even if they seem intimidating at first, you'll find that they're very easy to navigate. There is a table of contents, and the reason why these are publicly promulgated is because it's required by law. You can't be held or bound by law, required to be to be bound by law, which means you would have to comply to the law if you're not informed about the law. And therefore, these laws must be publicly promulgated, all right? So we're going to go to the statutes table of contents, and then we're going to scroll on down to Chapter 8C. You've also got Chapter 8 for evidence, and we'll get into that in another class session. We're going to go back and go to 8C for the evidence code. This is the chapter that is uniform with federal law, okay? And we're going to go to hearsay. We must first start with what is hearsay, Okay, so let's read in subsection C. Hearsay is a statement other than one made by the declarant, the person who's saying it, while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted, to prove the truth of whatever they're saying. Got it? All right. And there are exceptions. And this is why when a judge from a bench makes such a declarative statement that hearsay is altogether inadmissible in a hearing, it really teeters upon judicial misconduct and obfuscation, in that it is obfuscation. Obfuscation is a fraudulent misrepresentation or an intentional confusing of the facts with the intent to defraud, okay? All right, so let's see here. Now we're gonna go back. Now I want you to look at this. When we're talking about hearsay exceptions, when you hear that there are exceptions, you probably think, okay, well, maybe there's just a few exceptions because, you know, you've heard a million times over. I'm very certain you've heard it in everyday life, everyday conversation. Oh, that's just hearsay. That's, you know, that's not valid. Or you've heard, of course, in the court of law, if you've unfortunately been subject to a criminal case or even a civil case, and whether you were the defendant or the plaintiff, and you've heard hearsay come up in court, and you very likely, again, have heard a judge or an attorney say, well, that's hearsay and it's inadmissible, and say it in such a declarative, absolute fashion as though to suggest that there are no exceptions to hearsay. And again, that could not be further from the objective truth. And not only are there exceptions, there are lots of exceptions. Nearly 25, nearly. So we've got 24 because here there are other exceptions here as well. And we're just going to go over them very quickly. This is going to be a pretty quick lesson. I want these class sessions to be concise, informative, resolving the objective truth as it relates to whatever area of law and the subject of that area of law that we're covering, so that you are better informed. And again, if we know the objective truth, then we can have a better baseline on how we interact with one another. And I believe that it lends toward ethical rigor. And again, in that I am self-admittedly the ethical law professor, clearly ethics is core to my mission and my vision. So let's continue. Number one, present sense impression, a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. And this just basically means that it's from their immediate recall, and that would be valid. Get this on. There we go. If it's from your immediate recall, which is during the in real time when you're perceiving an event that is happening, again, in real time or condition, then your present sense impression is valid and not just hearsay, because you are directly observing it, and whether it is factually true or not is not so much as the the relevance of the statement that you're making, and instead your perception of the event or condition while it's happening in real time or immediately thereafter. And your testimony in that regard is definitely valid. Sometimes it goes to the criminal mens rea and actus reus, which means your mental intent, whether or not, when we're talking about mens rea, we're talking about your mental intent. And if it's criminal mens rea, then we're talking about your intent to commit a crime. So your malice, your anger, and anger is not always sufficient to prove malice, and we'll get into all that as well at another time. But generally speaking, when you're talking about criminal intent, you're talking about you fully intended to do exactly what you did with the intent of it resulting in the specific harm that you were inflicting upon another person. Okay? And your actus reus would then be your actions thereupon, which definitely coincide with your criminal intent when you were committing whatever crime or civil wrong upon another person. So hopefully that makes sense. And we will have some of these sessions live, so you will be able to ask questions. But in the beginning, as I've already alluded to, or actually straightly stated, I don't meet the threshold yet to go live, so we'll get around to that eventually. Again, get people in the building, subscribe so I can meet these thresholds and we can do so much more. All right. Number 2, similar to present sense impression, you have the excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. It's pretty straightforward. We'll move on to the next one. Then existing mental, emotional, or physical condition. So this is a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental feeling, pain, and bodily health, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the execution, revocation, identification, or terms of a declarant's will. Okay? So let's make sense of this. So effectually, when we're talking about then existing mental, emotional, or physical condition, we're still talking about the first 2 subsections, which are included therein. You're talking about a present sense impression. You're talking about an excited utterance of sorts. You're talking about what you perceived in that real time while the event or condition was occurring or immediately thereafter. And they limit you, as you see, but not including a statement of your memory or belief to prove revocation, identification, or terms of a declarant's will. So, and we'll get into will and estates, and we'll go into further detail about that, because there's a lot of specificity as to the application of hearsay rules and exceptions. But basically, what we're talking about here is you can't use it. Hearsay can't be admitted in this manner if you are using it on the basis of your memory or belief to prove a fact remembered or believed, because just what you believe is definitely different from what you perceived. What you perceived can definitely communicate and inform the criminal intent or negligent intent, or just the level of intent for whatever wrongs or crimes were committed and the person's intent who was committing it. So that should make sense to you with regards to perception. But what you believe, what you perceive, is more connected to your direct observation as opposed to what you believe or what you remember something to be as it relates to trying to prove a fact. And especially as it relates to proving a fact, remember to believe, of course, unless it relates to the execution, revocation, identification, or terms of a declarant's will. Because those can be relevant with regards to the determination for probate. And again, we'll get into that in a later class session. Let's continue on. Statements for purposes of medical diagnosis or treatment. And this should be self-explanatory as well. Statements made for purposes of medical diagnosis or treatment and describing medical history or past or present symptoms, pain or sensations, or the inception or general character of the cause or external source thereof, insofar as reasonably pertinent to diagnosis or treatment. Let me make sure, I want to make sure you see me here. Yeah, let's make sure. All right. Okay. And the reason for that, again, is it goes right back to the same purpose of the applicability of present sense impression, excited utterance, in that you are perceiving the symptoms, the pain, the sensations, the inception or general character of the cause or external source, thereof, insofar as reasonably pertinent to diagnosis or treatment. All right. And so these are admissible, although hearsay, because it goes directly to your perception in real time of an event or condition or immediately thereafter. So that's that, and that entails a direct observation. And that's the reason why that type of hearsay can be admissible in a case. Subsection 5, recorded recollection. So there's, and we'll get into this as well, there's also a common myth that a witness who is giving testimony somehow must remember everything to a T. And if they don't remember everything to a T, then they must be lying. Well, that's not the case. The law allows for presenting documents and presenting examination questions to a witness on the stand that helps them to recall a situation. Think about it. Some cases don't go to trial for a year or 2 years later after the actual event in question happens. So it is not unusual for someone to need recall on things like the time. Maybe they remember the period of the day. Maybe they remember it was night, but they don't remember that it was specifically, that this event specifically happened at 8:17 p.m. And so it is perfectly lawful for the examining attorney or examining party, plaintiff or defendant, plaintiff, and it depends on the witness, whether it's cross-examination or examination. So examination would, of course, be when the moving party generally, or the party who actually has brought this witness before the court, they would examine their own witness, and then the opposing side would then be able to cross-examine, ask them questions thereafter. So this reported recollection, a memorandum or record concerning a matter about which a witness once had knowledge, but now has insufficient recollection to enable him to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in his memory, or her memory, and to reflect that knowledge correctly. If admitted, the memorandum or record may be read into evidence, but may not itself be received as an exhibit unless offered by the adverse party. And that just is to promote fairness, if you will. So if the adverse party says, okay, well, yeah, let's go ahead and admit this, then again, like I said, it's to promote fairness, because it's already going to be admitted and doesn't necessarily need to be an exhibit as far as in proving facts that have not been stipulated. And so if the adverse party agrees to that exhibit being admitted, then that typically is going to occur through stipulation. And stipulation is just saying, hey, we agree, the plaintiff and defendant agree that this exhibit is material, and material, all that means is relevant, and we're going to admit it if, of course, the court admits it, and allows, it to be admissible. Okay? Excuse me. Subsection 6, records of regularly conducted activity. And that should make perfect sense. Even though when you're talking about hearsay, you're talking about statements made by somebody else that the witness themselves didn't directly observe or didn't directly conduct themselves. What we're talking about, conducted activity, right? But if it entails business records, medical records, any records for that matter, like it says, a memorandum, a report, a police report, the contents of the police report, even if the police officer was not present when the incident occurred, there still can be some relevance in the contents of the police report. So sometimes even when exhibits are admitted and it falls initially within the definition of hearsay, and then in situations like this where it is determined by the court that they are records of regularly conducted activity, that report in its wholeness still may not be relevant. And again, when it comes down to it, the stipulation is generally what then takes place to have a concurrence on what exactly are the undisputed facts in the case that will be heard on trial. And I know that may sound a bit confusing to some of the law students, and maybe some of you who are not laypersons and you have some information of maybe you're informed in law, because when you're talking about undisputed facts, you would generally think, okay, well, if there are no undisputed facts, then we're talking about summary judgment. Don't get ahead of me here. Don't think about disposal of the case or anything like that, because there's also the step pretrial procedure, and in that litigative step prior to trial, there can be a stipulation as to admissible exhibits. All right. And so I'm talking about just that in the specific aspect of the stipulation and hearsay and the admissibility of hearsay before trial. And that the reason again is to promote fairness and to prevent there being this surprise witness or surprise evidence that is brought during trial that the inferior party or the party that would be affected by that surprise evidence, they have an opportunity to actually prepare in advance for that on trial, as opposed to being surprised and then having to scramble and prepare a defense as it relates to that evidence at issue. Now, we see that happen so often in the movies, honey. They make it so dramatic. But generally speaking, when the court is operating and fully regarding the due process rights of both parties or all parties involved, because sometimes there can even be a third party, which would include like a cross claim. We'll get into all that as well. Then those type of surprise evidence situations, they are not only few and far between, but they are condemned, and they are generally subject to being stricken from the record if admitted in a manner that prejudices the jury, against the affected party, if you will, or the attorney themselves, or the party who attempted to admit this surprise evidence. They could also be held in contempt. Just depends on the court, and it depends on the judge and all the things. All right, so let's keep on going. But yeah, generally anything that is a memorandum or report, record, or data compilation in any form of acts, events, conditions, opinions, or diagnoses made at or near the time or from information transmitted by a person with knowledge, if kept in the course of a regularly conducted business activity. So this is why they tell you that, keeping a written record is so important, because if it was intermittent and, let's say that it was a doctor, right? And the doctor is a witness in a case, and they kept a separate log, but only intermittently, of their own personal notes about a particular, patient or case or whatever. And then they try to bring that to the court as admissible hearsay. That's probably going to be it's probably going to be a fight. They're probably going to really have to prove up the admissibility of that record, because it wasn't necessarily done in the regularity of that, of that keeping of the record, and it wasn't necessarily done in the direct course of their profession, or with them having that personal knowledge. So it could be hit or miss. All right. So we'll keep going. And it can also include affidavits as well. Authentication of evidence by affidavit shall be confined to the records of non-parties, and the proponent of that evidence shall give advance notice to all other parties of intent to offer the evidence with authentication by affidavit. The term business as used in this paragraph includes business, institution, association, profession, occupation, and calling of every kind, whether or not conducted for profit. All right. So number 7, subsection 7, absence of entry in records kept in accordance with the provisions of paragraph. And so that makes sense. So the absence altogether, as opposed to this kind of like intermittent record, if you will, or this, I don't want to say non-official, because a non-official record that was kept regularly would fall within the admissibility guidelines under subsection 6. Okay, it is very likely that a court would rule that it is admissible. Now, keep in mind, when I speak affirmatively, I'll normally use the term likely, and that's good practice when learning law in an educational setting like this, because there is no guarantee that anything that I'm saying, there's no guarantee that anything that I'm saying is going to necessarily apply to any specific case. Your case, your friend's case, somebody you know. And the reason being is because on the positive end of it, there just may be different circumstances, period, that inform a different decision by the court, by the judge, okay? And then on the bad side, on the negative side, Unfortunately, due process is not always fully regarded by judges, who are presiding over a case. And so, whereas the hearsay may be admissible by law, it may not have been deemed admissible by the presiding judge. And the remedy and relief for that would be on appeal or some type of pre-appeal motion, if you will. And we'll get into all those things as well. There's a lot with procedural law, so trust me, get in here because it's a lot to learn. It's a lot to learn, all right? And this also should help you in wanting to make peace with your fellow man. Yeah, I'm a huge proponent for it. And excuse me, I actually have a standard, in fact, that I go through a very deliberate process of trying to resolve a dispute with my fellow man without the intervention of the court. I have a very specific process that I go through. And so if you've ever seen me get to a complaint, then incorporating that standard, which I will disclose, I won't disclose it in this particular class session, but I will disclose it. It's not secret information. I think it lends toward and demonstrates high ethical rigor. But basically, if I ever get to the complaint stage where I'm initiating a complaint against a party that has wronged me, please understand that it was necessary. It was necessary, and it means that the person that wronged me or that committed a crime against me was either uncontrite, which means they could care less. Yeah, they was with the poops, right? Or it means that we just could not come to an agreement and settle without the intervention of the court. And oftentimes in that regard, for me, it's more often that the person is, or the business is being belligerent or non-compliant altogether, and committing crimes or civil wrongs with either malicious intent or negligent intent. And it's very seldom that I've ever gone to court just for the intervention of the court to settle a matter. Like when I get to court, settlement is no longer on the table because I have gone through great effort, ethical and legal rigor, to try to resolve the matter outside of court. Okay. All right. So let's keep forward. All right. So then we go to 7. Absence of entry in records kept in accordance with the provisions, which is what we already read, subsection 7. So if there's an absence of the entry in records, then that would be relevant, right? Because think about it, that would be relevant if there's a missing document from regularly conducted reports and records and statements and data compilation. It could inform the existence of fraud, the existence of, and these are different types of fraud, right? The existence of embezzlement, the existence of misappropriation of funds. And so this is what we have here. It can even inform the validity of a will. If there's something missing, like an affidavit, as it relates to maybe a revision to a will, or some gift that is in dispute, whether or an inheritance, just any number of things. Okay. All right. So then subsection 8, public records and reports, again, for obvious reasons, we've already gone over, records, reports, statements, or data compilation in any form of public offices or agencies setting forth the activities of the office or agency or matters observed pursuant to duty imposed by law, as to which matters there was a duty to report, excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel. And of course, it says excluding, however, in criminal cases. So because the threshold for burden of proof is higher in a criminal case than it is for a civil case, and we'll discuss that because the threshold for burden of proof, of course, is what? Beyond a reasonable doubt in a criminal case, and then for a civil case, it is just the preponderance of evidence. So it's just on the civil side, it's just the likelihood that the truth of the matter asserted is fact, right? And over here, for the beyond a reasonable doubt, you need to prove that this truth asserted is factual beyond a reasonable doubt, okay? And so that's the reason why it would exclude, in some cases, with regards to criminal matters observed by police officers and other law enforcement personnel. And lastly, or in civil actions and proceedings and against the state in criminal cases, again, factual findings resulting from an investigation made pursuant to authority granted by law, unless the sources of information or other circumstances indicate lack of trustworthiness. Boom. What do we talk about? Fraud, embezzlement, concealing, complicity, maybe some type of accomplice liability, any of those things, okay? So then let's go to subsection 9. We're working this out really quickly here. Records of vital statistics. Again, we already know why. So again, when we're talking about hearsay, because sometimes you don't think about these things as hearsay, but it's a statement, because a report is effectually a statement. That's what it's, that's what it is considered in a court of law for legality purposes. This record, this report, is not the statement directly made by the witness on the stand. And it's being admitted because of its relevance to facts in dispute in the case, right? And of course, this is the reason why they can be admitted, because of their relevance in this very specific regard. And it's an objective, when you're talking about relevance, you're talking about the objectivity of the evidence. So records of vital statistics, that is an objective truth generally. Or there's also the flip side to this. When you're showing records, like I said before, records can also show fraud. So the record is still the record itself is an objective truth of the fraud. Do you see what I mean? Even though the record is showing something that is not true, that in that it's not true, and there's a record that evidences that fact, it then can be admissible, although it would be otherwise considered hearsay. Understand? All right. So records are data calculations in any form of births, fetal deaths, or marriages, if the report thereof was made to a public office pursuant to requirements of law. Okay. Then subsection 10, absence of public record or entry. Same difference. 11, records of religious organizations. We got that. Church records, deaths, divorces, legitimacy, ancestry. They have religious marriages, right? Family history, marriage, relationship by blood, any of those things, right? Okay. And then subsection 12, marriage, baptismal. I was just about to cover baptismal, because those things come into play as well, especially as it relates to religious marriages and settling, dividing marital property, after annulment or after divorce, when there is a religious marriage as opposed to a legal marriage. And I'll be honest with you, that's not my expertise. But I will and do commit to, because I'm a lifelong learner in this process, as a Juris Doctorate, pursuing license to practice law, and also pursuing law clerkship and a law professorship career. All right. Let's see. So then family records in subsection 13, that's pretty obvious. Statements of fact concerning personal or family history contained in family Bibles, genealogies, charts, engravings on rings, inscriptions on family portraits, engravings on urns, crypts, or tombstones, or the like. And again, generally that's informing wills, estates, and trusts, and things of that nature, okay? Subsection 14, records of documents affecting an interest in a property. Again, we're talking about property law, the chain of title, and that should be self-explanatory when you think chain of title. You know, who had it? What is the history of who owned this property or had interest in this property at any time? And that could include not only direct ownership, but it can include marital property, right? Which would be inherent, you know, from marriage, even though the person the wife or the husband may not have actually purchased it themselves. But if it was purchased during the course of the marriage, then they would have interest, or maybe children, or adopted children. And you know what? I'm going to look into that as well. We'll have a class session on that. My dean is amazing. Oh my God, my dean. And when I say my dean, you know, was my dean. Of course, I'm no longer in law school as a Juris Doctorate, but I still affectionately refer to her as my dean because she was just amazing. She's an expert in property law, having first begun her career in real estate, and even as it relates to marital property. And so when I tell you she was not going to allow me to not show proficiency in property law, even though that is not my area of direct interest. But yeah, so I've retained a lot of knowledge. I had to in order to have my degree conferred, and that'll be a story for another time. Maybe when you all are, when we have a live session and you have questions, or if we have a break and you're bored and somebody wants to know, I'll tell that story or whatever. But yeah, interest in property definitely would be relevant evidence, and of course it would be informed through records of documents affecting that interest in property. So that's straightforward, right? All right, so let's see here. Let me read that too, just to make sure that you are clear on that. The record of a document purporting. So purporting means that it's holding it out to be true, but not necessarily that it is true, okay? So, and the reason why admissibility would be likely for this type of document is because, again, it would help to resolve the facts in dispute as it relates to someone's interest in a property. So if the document purports interest, then it at least needs to be admitted for the purpose of scrutiny. So let's keep this in mind too, because I think there needs to be clarity there. Just because a document or evidence is admitted does not mean that evidence is a smoking gun. That is just part of statutory procedural law. It is just part of pre-litigation to make a determination, to scrutinize and consider all evidence and facts thereupon, or the facts that they are trying to glean therefrom, and then establish facts that remain in dispute, or otherwise facts that are no longer in dispute, and then you take that to trial. Okay. So then subsection 15, statements in documents affecting an interest in property. Oh, that's yep, same difference. The statements therein that should make sense to you. Sometimes there's a note from somebody who's recording the lien. Maybe there was a error, and maybe someone understood that they had interest in a property, or that interest had been taken away, and maybe they're going back to court because they are asserting their lawful interest in a property. Any number of things like that could occur. Subsection 16, statements in ancient documents, which is really cool when you think about it in one regard. Statements in a document in existence 20 years or more, the authenticity of which is established. Let's see, and that just should make perfect sense to you. And if you're not getting it now, then you will in the last the last 7. There are significant exceptions to hearsay, significant, and there's always exceptions to legal rules. Generally, please understand, whether it's directly in the statutory law and therefore is an enjoinment, meaning it's a mandatory, meaning that the judge, the court, mandatorily must regard it as statutory, procedural law directs. And I'm not saying that they must regard it, meaning they must admit the hearsay evidence. I'm saying that they must regard the law, which means they must incorporate the actual letter of the law, the plain language of the law. They must follow it, even if the outcome is not admitting the evidence that is questionable hearsay. Hopefully that made sense. I believe it should. Okay. All right. Then we've got market reports, commercial publications, newspapers, directories, tabulations, quotations. There you have it. That makes sense. Learned treaties. That makes sense. Periodicals, published treaties, pamphlets. These are all subject of history. Medicine or other science or art established as a reliable authority by the testimony or admission of the witness, or by other expert testimony, or even by judicial notice. If admitted, the statements may be read into evidence, but may not be received as exhibits. And that is a wonderful reiteration as it relates to whether something is admitted or not does not mean that it's going to be received as an exhibit. Okay? So there are steps to this, right? There are steps to this. Then 19, reputation concerning personal or family history. Reputation amongst members of his family by blood, adoption, or marriage, or among his associates or in the community concerning the person's birth, adoption, marriage, divorce, death, legitimacy of the child, relationship by blood, adoption or marriage, ancestry, or other similar fact of his personal or family history. Now, the first thing that always comes to mind with this is the history of slavery. And so when you're talking about how families were separated, and even after the abolishment of slavery, where there was still, the Jim Crow era, and there were still very strict, burdensome impediments for the civil rights of my fellow African Americans, and in certain areas in the United States. And so they would seek refuge in areas that did regard their freedom, that, did comply with their freedom. And oftentimes they would send a child or maybe someone, and they would then assume this informal adoption, and it would not necessarily be a formal adoption. And so that's what they're talking about when you're talking about reputation concerning personal or family history. That could definitely be the case. And they assume this in refuge from, being disenfranchised and hunted, All right, so subsection 20, reputation concerning boundaries or general history. So this could be maps. This could be customs affecting the lands in the community, reputation as to the events of general history important to that community or the state or the nation in which it was located. Reputation as to the character. So someone's personal character amongst his associates or in the community. Now, of course, again, reputation as to character is, that's a funky monkey one, right? Because you're talking about character testimony. May get into criminal convictions. Of course, that which is expunged generally cannot be brought up in a court of law. However, there are exceptions to every rule generally. So we'll tackle that in another lesson. But yeah, generally reputation as to character. And then the last two, subsection 23, judgment as to personal, family, or general history or boundaries, again, as it states in the ones above. And then lastly, other exceptions, a statement not specifically covered by any of the foregoing exceptions. Do you hear me? So the list is near endless, because not only we have a subsection 22 is now reserved for codification of another exception by the North Carolina General Assembly. We also have other exceptions, and this is kind of like a catch-all, if you will, generally speaking. A statement not specifically covered by any of the foregoing exceptions, but having equivalent circumstantial guarantees of trustworthiness. And that's the entire purpose of it. That's a wonderful statement to summarize exceptions to hearsay. If there is a circumstantial guarantee of the trustworthiness of a statement or document that would otherwise be deemed hearsay, then the court can validly determine that it is admissible. Again, that does not necessarily mean it will make it to the exhibit status, okay? If the court, and let me clarify this as well, because this can be confusing for some. So let me clarify this for you. If you've ever been in a case or you've been watching TV and you hear them, and especially the famed law, based shows, if you will, and they're talking about exhibits that they're presenting to the court, or this is this exhibit and I'm putting this in case record, or I'm filing these exhibits in support of my motion. Those exhibits are presented, they are proffered, which means that they are offered to the court, but they have the admissibility of those exhibits has not yet been determined by the court of law. And there has to be a determination on those exhibits generally. Now, you can add attachments and exhibits to pretrial motions, but when there's going to be a substantive decision that is made that will result in the disposal of the case altogether, or some major decision that affects the outcome of the case, then there has to be a formal determination on the admissibility and relevance and truthfulness or accuracy of that evidence, okay? So let's go back to it. Lastly, if the court determines that a statement is offered as evidence of a material fact, The statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable effort. So basically is that it has to be more probative. So it's going to be more relevant and directly so than it would be prejudicial to the party who is not presenting the evidence. So it has to be probative. It has to be material and relevant, tending to prove the truth of an asserted fact. Okay? All right. Let's see. The general purposes of these rules and the interests of justice will best be served by admission of the statement into evidence. So the default rule then, ironically enough, and this is what I mean by when I am so matter of fact in ascribing misconduct to a judge who would preside over a case and say flatly that hearsay is not admissible in the court of law, as if there's this blanket, that they're throwing over all hearsay and they will not consider any hearsay. Well, the letter of the law says quite the opposite. It says that the general purpose of these rules and the interests of justice will best be served by admission of the statement into evidence. So the default role should be to accept it. Because at the end of the day, now, of course, if, within reason, right, applying all these aspects of legal determination or adjudication that we've already discussed, right, the relevance of it, the reliability or the authenticity of the document or the statement, right, when, where, how, what, all those aspects are considered. But at the end of the day, it promotes the fairness, right? If it's just admitted into evidence, because it doesn't even mean that it's going to make it to the exhibit status, right? So your default rule is to give, everyone a benefit of the doubt and hear all evidence. And there is inherent to substantive due process, and substantive just means the intention, even if it's not explicitly stated in a procedural or in a statute on procedural law, it is still inherent thereto that there should be the highest regard for due process. And excluding all evidence is not consistent with due process. It's just not. It's just not. All right. And it doesn't promote fairness at all. So, however, a statement may not be admitted under this exception unless the proponent of it gives written notice stating his intention to offer the statement and the particulars of it, including the name and address of the declarant, to the adverse party sufficiently in advance of offering the statement to provide the adverse party with a fair opportunity to prepare to meet the statement. And that is exactly what I spoke about in the beginning. Promoting fairness means that neither side can present surprise evidence. And in a nutshell, that's exactly what that says. So I am so excited. I get so tickled pink about education generally, but legal education, especially, again, in the sense of personal fulfillment, the evolution of society, and betterment of our relationships, and your continued learning, so that we're better informed. I believe that when we're better informed, that what do we say? If you know better, then you do better. And I believe that is the core, the very essence of ethical rigor. And so I hope with my entire heart and my cognitive viability that you received and shall retain the information learned here today. If you have any questions, please feel free to put them down in the comments. Please subscribe, please share, and I'll see you in our next class session. No homework. All right. Have a wonderful evening, class.